Good morning, it's Alex Woods here. I'm a financial mis-selling litigator. I also consult to the insolvency sector, and I consult to a law firm in Norfolk, and I'm also, as a consultant solicitor, and I'm also consulting to a claims management company in Oakham. Part 6, this is obviously probably a question of immense importance to insolvency practitioners across the country. How much can I charge for the whole business of realising PPI assets within IVAs? Now, I got ticked off the other month because I talked about the grubby subject of money. But in a way, I don't apologise for this, because I think it's arguably in the best interests of everybody, both creditors, debtors, and indeed the insolvency practitioners themselves, who are struggling to make any sort of money or run any sort of proper business from running IVAs. I think it's probably in the best interest, therefore, to ensure that the IVA is properly funded. And the way I like to look at the PPI mis-selling scandal, it's my favourite metaphor, is an oil slick. And the insolvency practitioners are tugs, are those, tugs that clean up oil slicks by squirting detergent on the ocean. And the financial mis-selling sector is an oil slick, and it has to be cleared up. You can't just leave this financial mis-selling to fester. So there's my soapbox. Don't worry, I'll soapbox but once in this video bulletin. Now, I'm going to firstly touch on the guidance note. I'm then going to talk about audit fees, and I'm then going to talk about the issue of, well, a couple of ideas actually, trying to open it up to look at sort of the issue creatively and to see how best insolvency practitioners can effectively and in a financially viable way charge for processing PPI. Then I'm going to look at some stats. So do hang on at least for the stats section, the fourth section of this video bulletin, because I'm going to go through an email that I wrote to an insolvency practitioner who wants to do business with us, and gave him the nuts and bolts of the stats. Then I'm going to conclude by reference to SIT 9, no less. So, the problem. Now, as the guidance note points out, whether explicitly or reading between the lines, there is something of a problem for insolvency practitioners in terms of properly charging for the processing of not just PPI but all financial mis-selling claims, because, put simply, no one envisaged a payment protection insurance scandal when those, I was about to use the word nasty, but that was a pejorative term, those business-like creditors decided that it was best to insert modifications and to hold insolvency practitioners to account, as 'twere, on a fixed fee basis for the remuneration they were getting from running their IVAs. Unfortunately, of course, at the time that fashion of the modification fashion, which is sort of more relates more to protocol post 2008 IVAs than it does to the R3 ones, and of course leaving aside all the variegated exceptions that there will be in the case of individual IVA proposals. But that does, where there's silence, where there is otherwise silence on this whole issue, that does leave the insolvency petitioner with a bit of a problem. I will wrap up with a conclusion of what I think in the final section. But the first thing I want to say is really rather put the ball back in view of the insolvency practitioner's court, which is, needless to say, a appropriate metaphor, as it's the penultimate day before Andy Murray hopefully wins Wimbledon, the first time a Brit had done it in 77 years apparently. So I'm going to put the ball back in your court and ask you the question: is it really not possible to convene a meeting of the creditors to suggest a variation such that you're able to charge for the processing of PPI and other financial mis-selling claims, and then, because the creditors obviously are going to grumble, go to the court and put the matter before the court. Because I think this is an eminently fair thing to be doing, because no one envisaged the PPI scandal, and no one quite saw that, you know, you've got this unique situation in which the creditors themselves are guilty of the wrongdoing. And it's not just a mutual set-off necessarily, it is actually potentially some bad faith there. So I like the idea. I know it's you don't want to litigate, and I know that it could be time consuming. You've got to sit down and spend another couple of hours at the end of the day to put some sort of application to the court together. But you could draft the application to the court, could you not? And then convening a meeting of the creditors and then say, look, this is what I'm going to do. Do you want to pay? And perhaps not a majority, maybe, perhaps a substantial number of those creditors will be debt purchasers. This is what I'm going to do, because I think it's only right that I should be able to properly charge for the processing of financial mis-selling claims. Now, don't run off into the hills yet, okay, those who are saying, oh, well, no, the creditors have told us, you know, if you can't stand the heat, get out the kitchen. Don't run off into the hills yet. Why I put the ball back in your court is because, of course, the key question is, well, one of the questions that I have that you will know the answer to is, you know, do I have to do this for each and every IVA that I possess? Or can I, on a more general basis, go to the court and invite the court to make an adjudication on this point across all my IVAs, and then use that in order to vary all your IVAs? Okay, so that's the key question. Otherwise, it does appear, because you know, you can't just bill it as a Category 2 disbursement, and you may therefore, and you probably, many of you probably already are, using a third party to process financial mis-selling claims. But it does appear it's pretty difficult to properly remunerate yourself for processing of financial mis-selling claims. Okay, that's the guidance note. I've rattled through it. Comments, please, if you've got questions and if you want to sort of debate this further. I'm now going to come on to the issue of the audit fee. Now, speaking to an insolvency practitioner a couple of weeks ago, and I was saying to them, look, you know, an audit fee, and I'm pitching this fee at anywhere between £100 and £300 per IVA, is essential. Because it's very difficult, particularly for a law firm that has red tape overhead, as opposed to a claims management company that maybe not have quite a substantial overhead, but even so, there's complexity in processing PPI within insolvency. I've posted a video on it's not as simple as writing a letter, and I think that in open IVAs, I don't think it is as simple as writing a letter. If you're doing a proper job, you're a medium, a small-sized insolvency practitioner. Obviously, the big IPs will find a way to, you know, to process it and to push it all through. But, you know, I do think the audit fee is justified because it is tricky cash flowing the bringing of financial mis-selling claims. And believe me, you know, the lending community is not in a hurry to discover the existence of a PPI claim, particularly, let's say, if it's a consolidated loan, and they may not be in a hurry to tell you that there are potentially previous historical PPI claims on the back of previously consolidated fixed-term loans. They're not going to be in a hurry, and I speak from experience here, unless they've suddenly changed in the past 3 months. I speak with experience here, going to court with, you know, applications with disclosure. They're not going to be in a hurry to point out a missold payment protection insurance product on a credit card, where they have basically subcontracted an office somewhere to come in and flog PPI, which they did on top of credit cards where they hadn't originally sold it in the first place. Big sales exercise. You read the FSA's report on the OFT's reports on all of this. They absolutely flogged this product, and the people who were flogging it were on, could as much in some cases double their salary for doing so. They are not in a hurry, particularly where a lot of banks, Lloyds, I've come across this in Lloyds. Lloyds actually stuck PPI on credit cards. I'm talking about an odd couple of cases here because I don't deal with thousands, but and then later on we discovered that they'd removed it in mysterious circumstances. Had they done a review and decided what they'd done was slightly dodgy, and so it doesn't appear on the recent credit card statement. So you got to then chase them and audit them. This job is not all about just getting the money processed from the banks through the third-party service company into the IVA. It is about making sure that you have, you've not just taken a bite out of the apple, but you've eaten it down to the core in terms of realising the asset in full. Other people have different views. That is my view. That's the professional way to do it, and that's the way to maximise realisations. Now that process, don't be beguiled by 15 or 20% offers. Think about, I think 25 to 30% is the range that third-party companies should be charging. So I think an audit fee is category 1 audit fee is appropriate to help that business to cash flow itself, because you've formed a partnership with them. And I know that a big claims management company, Equity and Finance, was on the brink of cash flow problems, and then it did then it did introduce audit fees. Well, I say no, that's somewhat anecdotal. But I also talk from experience in terms of the law firms that I've been affiliated with. Looking back, from day one, I'd have been making sure the audit fee was part of in the service agreement with the IP. Now, there's an exception to that. I was talking to an IP a couple of weeks ago, and it was, it's interesting. It's quite a significant exception. If you're just generating a new IP may have a new IVA, may have no money in the pot. So for new IVAs, perhaps this audit fee shouldn't apply, or it shouldn't be as large. Alternatively, don't forget this is refundable from the realisation when it comes through. It's a business relationship, I think you should be forming with this third-party service company if you're not doing it in-house yourself. So that's my views on audit fees. I declare an interest because I do have a relationship, obviously, with third-party service companies. But the other thing that occurred to me whilst I was preparing this video bulletin, the second sort of an idea really, was whether or not insolvency practitioners couldn't take the audit stage of processing financial misselling claims under their own roofs. If they were able to get modifications inserted into the IVA or make applications to the court or whatever, they could then bring it to the auditing process I'm talking about, actually discovering the truffle rather than discovering the existence of truffles rather than actually digging them up and processing them and turning them into cash. I think that's a job that perhaps with help, it's going to sound like a plug because I encourage consultants to find someone has expertise in the area to help them to audit, or at least to get a bit of phone call advice. I would encourage you to look at this, because it may be that you can undertake that exercise under your roof, and then you can be taking the £200 per IVA figure across all IVAs and helping to oil the wheels of the IVAs and helping to make sure that the IVAs are available, because I think they are a great debt management tool, are available for consumers in the future. When the interest rates go up there because inflation gets out of control, whatever. So that's one idea that you might like to look at. So I'm now going to come on to the stats, and I'm just going to, I think I'm going to read this to you, just so, it seemed to me really important when I set up these video bulletins that indeed when I set up as a financial misselling litigator 4 years ago, that because there's been such a comprehensive, appalling lack of transparency in the way payment protection insurance has been sold to Joe Public, and a lack of transparency in the way the claims management cowboys then jumped on the bandwagon and started to charge upfront fees to consumers and all the rest of it, that it was important to be transparent about what I was doing as a solicitor, as a specialist in the sector. hence these video bulletins in very many ways, other than it's an opportunity for me to, to soapbox first thing on a Friday morning. And so that's why I sort of sail quite close to the wind on these issues, and I try not to breach any sort of duty of confidentiality, as I am a solicitor. But anyway, here are the stats. So I would advise you to work to a conservative figure of around £3,500 realisations per IVA before your 15%. An average PPI breaks down this way. An average PPI claim of 2,550, and 1/3 of all debts in an IVA have got PPI. It's quite a lot. If you assume 10 debts per IVA, you have around 3.3 times 2,550, which gives you 8,415. But you would reduce this by 30% to account for a 70% success rate, because not all cases of PPI missold. So you turn this into £5,890. Then you would reduce this further to account for where the creditor attempts set off. Now I reckon a figure of 15% is not unlikely. About 25 to 30%, according to the stats the law firm I'm working with, attempt set off. But, and this is, I was going to say surprising, perhaps it's interesting, and it bears out my intuition about the unfairness around this whole area, is that while 25 to 30% of lenders attempt set off, HSB are good at it, Co-op are good at it, Royal Bank of Scotland are good at it, MBNA completely good at it. Capital One spin the whole argument the other way around and tell you that your client, even pre-2008, was under a duty of disclosure and should have told their IP about the PPI claim that Capital One had unlawfully flogged to them, and have breached their duty of disclosure. So Capital One completely turned the thing and asked about tit. So, but when you do argue these points, they tend to capitulate down to 15%. 15% reduction gives you £5,007. You then deduct by 30% to the service company on a conservative basis, £3,505. So you're looking at £3.5 per IVA, and I don't think that is a bad basis for you to do an internal assessment on whether or not the cost of realising PPI claims is likely to be absorb the proceeds. And I've done that on a conservative basis with you in mind, so that it's a conservative basis. Don't forget that in terms of time frames, could be looking at 6 months, could be looking at 18 months if it goes to Financial Ombudsman Service, who are inundated and are recruiting 1,000 new staff. In about 2 years' time, they'll have 3,000 staff. So it could take a while. And then there's some complex cases that I believe still litigation is still required in a number of cases, and particularly where you dispute the quantum, the offer that's been made by the lender in question. So there you go, those are the stats. It's a fluid situation, but hand on heart, I would use those stats if I was you to assess the viability of processing PPI claims. I'm going to conclude by quoting you your own code. Payments to an office holder or his or her associates should be appropriate, reasonable and commensurate reflections of the work necessarily and properly undertaken. SIP 9. I'd like to hear from insolvency practitioners. I've commented, debated this on LinkedIn. I'd like to hear, can you not apply to the court and get the court to take a view that you are entitled, even though the modification has been inserted by the creditors, that because this PPI scandal is an unforeseen event and its complexion is unusual, let's be frank. I mean, as an insolvency practitioner, you can't often be coming along with whole-scale, potentially unlawfully sold products to the creditors that you're meant to be, by the creditors whom you're meant to be representing. So, I wonder whether or not going to the court isn't one way of ensuring that you modify the modifications and perhaps allow yourself to, to whether you're using a third-party service company or whether you are doing it in-house, whether you're taking up the audit part of the operation under your roof, relax the stringent rules that they've been on IVAs in recent history, so that you can be properly remunerated for the necessary work that's required to be undertaken. Very many thanks, and I do welcome a post or an email to info@redwoodlegal.co.uk.